Washington Journal continues.
We have two people who are going to be joining us in this next 45 minutes to discuss the hearings coming up today and the bigger issue of FISA. But first I want to show you a picture in this morning's New York Times, which will be a flash from the past for a lot of people. This is Senator Frank Church, Democrat of Iowa, talking to reporters in July of 1975, and the cut line says that the Senate committee he led revealed that the National Security Agency had intercepted the phone calls and telegrams of Americans. Joining us from Virginia this morning is Robert Turner. He co-founded the Center for National Security Law at the University of Virginia. Mr. Turner, what is the relation between the Church Committee and what's happening today?
Well, the Church Committee politicized some problems in the intelligence community. That led to what I think are some unconstitutional laws, or some laws that have constitutional problems and applications. Among other things, for example, FISA came directly out of the Church Committee, and when Colleen Rowley, you remember the Time Woman of the Year in 2001, went to the FBI and wanted to get a warrant so she could examine Zacarias Moussaoui's laptop computer, they turned her down, and everybody believes that's because the FBI is incompetent. In fact, it's because when Congress wrote FISA, it did not consider the possibility of a lone wolf terrorist, and thus it was illegal for the FBI to get a warrant for that case. If you go back to the Church Committee, there was all sorts of talk about the CIA being a rogue elephant and so forth, which Frank Church, after his hearings were over, said, well, really that wasn't true. Everything they did was approved by the president or authorized by the president or other politically accountable cabinet members and so forth. You may remember one of their big issues was the CIA had a big assassination program. When they finished their investigation, they could not find a single instance where the CIA had ever assassinated anyone. They did find 2 instances where they made decisions and one where they actually attempted it. That was Fidel Castro. So a lot of the problem, I think, is that Congress, in the wake of Vietnam, passed a number of statutes that were, at least in part, unconstitutional, the War Powers Resolution being another one, and this has now come into conflict with the president's independent power in this area.
Glenn Greenwald is a constitutional law attorney. Mr. Greenwald, what's your take on how the church hearings relate to what's happening today?
Well, the reason why we have a law in place, why FISA exists, is because there's been a history of abuse on the part of the executive branch of the eavesdropping power, which is an extraordinary power to be able to listen in on any communications anywhere in the world, including in the United States. And there was a long history of abuse of this power, where presidents were using it for their own political purposes and for their own use rather than for national security purposes. And as a result, all of our representatives in government, in the Congress, in the courts, and in the executive branch came together and agreed that while surveillance is an extremely important tool for our country to use, it is imperative that it be used only with oversight, only with judicial oversight and with judicial approval in order to ensure that that power is not being abused. Professor Turner referenced some flaws that he thinks exist in the law. We are a country of laws. We live under the rule of law. And if there's a law that's inadequate or that is somehow too weak, the solution in a country that lives under the rule of law is not for the president to secretly violate the law and decide that he has the right to break it because it's not a good law. The solution is to amend the law, to change the law, and to fix it. And I think what's critically important is that FISA in 2001, in the wake of September 11th, the September 11th attacks, was amended by the Congress working with the Bush administration. The Bush administration said in the wake of 9/11 we need expanded powers of surveillance. The Congress agreed. Democrats and Republicans almost unanimously, by a vote of 99-1, voted to amend FISA to give the Bush administration everything that the administration said it needed in order to effectively eavesdrop against al-Qaeda. George Bush, once those amendments were enacted, praised the law lavishly by saying, "Thank you, Congress, we can now eavesdrop on the sophisticated means of communication used by al-Qaeda." And what he did instead, weeks later, was order that the law be violated and that eavesdropping take place not with judicial oversight but in secret, exactly what the country in 1978 decided by consensus that it did not want.
Mr. Turner, in 1978, where were you?
I was a member of the staff of a senator who was on the Senate Foreign Relations Committee. I was National Security Advisor to Senator Bob Griffin of Michigan.
And what were you doing in connection with the FISA Act?
I followed it, but he was not a primary player in it, so I had followed the church hearings and also followed all of the laws that were passed in connection with it.
And what do you think of Mr. Greenwald's contention about the legality of what is being done today?
Well, he's exactly right. We're a nation of laws. What he's missing is there's a hierarchy in our political system, our legal system. The Constitution comes first. Every court that has considered this issue and made a decision on it, which includes 3 circuit courts of appeals and the FISA Court of Review, has held that the president has independent constitutional authority to conduct foreign intelligence surveillances. Now, the Supreme Court has narrowed the original understanding of the president's power. In 1972, in the Keith case, Justice Powell, for a unanimous court, said when the target is entirely a domestic target, in that case it was a Black Panther, the president must get a judicial warrant, but the Supreme Court distinguished that from a case involving a foreign power or agent of a foreign power when the FISA Court of Review, which was created to review the Foreign Intelligence Surveillance Court decisions by the FISA Act, when it, in 2002, issued an opinion, it noted that all of the courts of appeals that have considered this have upheld independent presidential power and noted we assume that is true, and if the president does have this power under the Constitution, it cannot be taken away by simple statute like FISA. And this is really the key. The Founding Fathers, I did my 1,700-page doctoral dissertation on this issue, on separation of powers regarding intelligence, and if you wanted to, we could go back and talk about all of the key Founding Fathers: George Washington, James Madison, Thomas Jefferson, Alexander Hamilton, John Jay, John Marshall. All of them said that when the Constitution gave the president the executive power in Article 2, Section 1, that included the foreign relations power, subject to some very narrow checks. So to me, this is an easy case. We have a constitutional issue. On the one hand, privacy is protected by the Fourth Amendment, which is just as important today as it is in peacetime, except it's not absolute. Remember, the Fourth Amendment prohibits only unreasonable searches or seizures, and what constitutes a reasonable search does change during wartime because the determination is based upon balancing competing interests. On the one hand, you have the privacy interest of the citizen or permanent resident alien, the U.S. person, and on the other hand, you have the legitimate interest of the government, and the court has repeatedly said that no governmental interest is more important than the security of the nation.
We are going to open up our phone lines and invite you to join us this morning. You'll see the phone numbers at the bottom of your screen. If you are a Republican, 202-737-0001. For Democrats, 202-737-0002. And for Independents, 202-628-0205. First call, Modesto, California. Good morning.
Good morning. Liberals mainly and others have stated that our National Security Agency has been spying on Americans. However, I doubt that all calls from people in the U.S. to terrorists overseas have been made from U.S. citizens. And if U.S. citizens have been making calls to terrorists, I would not refer to them as Americans. I believe a better name for them would be potential traitors or terrorists.
Thank you. We go to Harper's Ferry, West Virginia.
Good morning, Connie.
Morning.
Young people like you have forgotten, but Frank Church was not a senator from Iowa, but rather from Idaho.
Did I say Iowa? I knew it was Idaho. Sorry about that.
That's not what I called for, though. I called because I don't care if that guy wrote a 17,000-word dissertation. If the president can order these things up with no supervision from any other branch, but solely on his own hook, we've got a dictatorship, and we just ought to change that. It's not right.
Thanks. Edinburgh Falls, Vermont. Good morning.
Good morning. Can you hear me?
Sure can.
Well, yeah, I guess I'd have to second what the gentleman just said. You know, if any chump that gets installed in office after not being elected can declare war, and I need to emphasize, we're not at war. Al-Qaeda is not a threat to this country, and we're not at war. So if any chump that gets installed in office can break the laws as he sees fit, I predict we will not even have an election in 2008 because he'll declare martial law. We are really finished as a country and the Constitution is a dead letter. Thank you.
Mr. Turner, what are you hearing?
Wow, an awful lot of sad confusion. We are at war. We know we're at war for a variety of reasons. Most important, the United States Congress, the body empowered by the Constitution to declare war, with only a single dissenting vote, has declared under the War Powers Resolution that the President is authorized to fight this war. We've got other things. The UN Security Council has acknowledged that the right of self-defense applies, and that's only applicable in cases of a war, basically. NATO, for the only time in its history, invoked Article 4, which is the armed attack language that says one of our members has been attacked, there's a war, we all now will respond and assist. This is not unchecked power, first of all. NSA itself has 200 inspectors as part of their inspector general shop. They've got lawyers. Justice Department has a large office called the Office of Intelligence Policy and Review that reviews all of this stuff. There's a lot of check. This has been reported to Congress more than a dozen times. The chairman of the Senate Intelligence Committee has said he knew about it. He believes it's fully legal. There's a lot of silliness here on this. Now, the Supreme Court, in its most famous foreign affairs case of United States versus Curtis Wright Export Corporation, noted that foreign affairs is different under our Constitution. And into the area, it was talking about diplomacy in that case, but it's even equally true of intelligence. Into the area of negotiations, the Senate cannot intrude. Congress itself is powerless to interfere. Go back to our very first major, most important constitutional law case, perhaps of all times, Marbury versus Madison. Chief Justice John Marshall, first of all, he said, an act contrary to the Constitution is not law. And then he went on to say that under the Constitution, the President is invested with certain important political powers in the exercise of which he is to use his own discretion, and he is accountable only to his conscience and to his country and his political character. That is to say, if he runs for re-election and the people don't like what he did, they can obviously throw him out of office, but there were no checks. Why are there no checks? Because the business of war requires speed and dispatch, and you cannot go back, you cannot tell a soldier before you pull the trigger to kill an enemy, you must first take him back before a federal judge to determine beyond reasonable doubt that he is an enemy combatant, that he's not a U.S. citizen, whatever. Under the Constitution, the President can authorize our soldiers to kill U.S. citizens if they go out on a foreign battlefield and try to kill us. Go back and read the 1942 Quirin case, where the Supreme Court upheld the trial and execution by military court of U.S. citizens, and they noted when U.S. citizens join the enemy, they're liable to be treated like the enemy.
Mr. Greenwald.
Professor Turner's views are unbelievably radical and I think completely contrary to every basic value that has made our country great for the last 225 years. The Founding Fathers would be shocked to learn that they created a system of government where we have a president who can, without what Bush defenders call interference from the Congress, which is the people of the United States and the representatives, or the courts, can make decisions about how Americans are detained, how Americans are eavesdropped on, how Americans are interrogated, not just abroad, but also in the United States. The power that Professor Turner is describing is the power of a king. It is the power of someone who has the right, even once the legislative body passes a law making it a crime to engage in certain conduct, to ignore that statute and engage in that conduct anyway. That is what Professor Turner is defending, and that is what the Bush administration has done. Throughout our country's history, the President and the Congress have shared legislative and executive powers. We have never had a system of government, nor should we want a system of government, where once Congress passes a statute making it a crime to engage in certain behavior, and here the President and the Congress got together in 1978 and made it a criminal offense to eavesdrop on American citizens without judicial oversight, for the President to then have the right to then go and do that is to create a government where there is no checks on executive authority. And I want to emphasize how radical that is. The other point that I wanted to make is the Bush administration has never once claimed that FISA is unconstitutional, nor did they ever claim that FISA could not limit what they could do. To the contrary, for the last 4 years, President Bush went around the country and falsely urged the American people to realize that eavesdropping is not a threat because the government eavesdrops only with warrants under FISA, which was false. Attorney General Gonzalez went to Congress and told Congress that there was no eavesdropping without warrants. That was false. And not only that, but President Bush signed into law amendments to FISA in the wake of 9/11 designed to make the power of eavesdropping broader. It is absurd now that he's been caught violating that law to say that the same law that he signed into law through amendments and praised as being an important change to the law is now suddenly unconstitutional. There's a history of deceit on the part of the administration with regard to what it is that they were doing. If they had the legal authority to break the law, if they had legal support and constitutional authority to eavesdrop without warrants, they would not have engaged in this history of deceit for the last 4 years against the American people and against the Congress.
Union Springs, New York.
Good morning.
Morning.
It amazes me, the Democratic Party in this country. When we were attacked on September 11th, 2001, the Democrats were all screaming, oh, George Bush should have been watching over what was happening with these terrorists. If he had been doing his job, this never would have happened in the first place. Well, now he's been doing his job and keeping tabs on what these terrorists are doing, people in the United States who are talking to the terrorists in foreign countries. Now he's doing his job. Now the Democrats are screaming, oh, our civil liberties. This isn't about decent, upstanding citizens in the United States. This is about people who support terrorists. You know, the ACLU and all these people who are so concerned about the rights of these terrorists, maybe they should have been in the building on September 11th instead of all those decent Americans who were murdered by these people you're so interested in keeping their civil rights up front. Thank you.
Mr. Turner.
Wow, lots of things there. Now, if this were presidential deceit, the president would not have reported this to Congress more than a dozen times. The fact that it's not made public to the American people is very simple, because we can't tell the American people anything that our enemies are not going to hear. Glenn says that this would have shocked the founding fathers. Name one of the, if you'd like, I've got with me a copy of one of the volumes of Thomas Jefferson's papers. Jefferson, April 24th, 1790, wrote a letter to the President Washington, and he said, under the Constitution, the President is given the executive power. The conduct of business or the transaction of business with foreign nations is executive altogether. It belongs then to the head of that department, except for such portions as are specially submitted to the Senate, and exceptions were to be construed narrowly. 3 days later, George Washington wrote in his diary that he had had some conversations with Representative James Madison and with Chief Justice John Jay. They agreed with Jefferson that Congress had no right to interfere in this business, it being executive and entrusted to the president. The idea that the president thinks he's above the law or is violating the law when he authorizes military operations is silly. And remember, every one of these conversations that was intercepted involved an international call. This is not domestic spying. These are conversations or communications, emails, what have you, between foreign nationals in foreign countries and people in this country. And every one of the foreign nationals was either a known or a suspected member of Al-Qaeda or another terrorist organization related to Al-Qaeda. Now, we probably picked up some totally innocent calls. It may be that Osama bin Laden bought a lamp on eBay and sent somebody an email saying ship it to General Delivery, Islamabad, Pakistan. We don't know that. But the question is, because of that slight risk, are we to tell NSA whenever an American is involved in the communications, and by American I don't just mean citizens, you have to unplug your headphones and not listen? This is silly. The people who blew up the World Trade Center lived in this country and were in communication by email and otherwise with our terrorists. This is a very important program. It's fully law. Just 2 more points. Not only did Bush say that FISA cannot interfere with the president's power in this, but when this act was first passed in 1978, Griffin Bell, the Attorney General, a very distinguished former Court of Appeals judge, told Congress, I see there's nothing in this bill that recognizes the president's independent constitutional power in this area. Obviously, this statute can't take away that power. In I think it was 94, when Jamie Gorelick, the Deputy Attorney General, went to the Congress to get an expansion of FISA to include physical searches, She said, don't misunderstand me to think that we don't believe the president has independent power to do this. He does. So you've got every court of appeals that's ever considered it on the president's side. You've got the appeals court set up by FISA saying not only that all the courts have established this power, but we agree with, or we assume they're right, and if they're right, FISA could not take that power away.
Mr.
What we're
Greenwald,
talking about.
Caller, I'm going to interrupt you, Mr. Turner. Mr.
Sure.
Greenwald.
I want to make a couple of points. The first one being that the caller, I think, referred to, and I know Professor Turner did, referred to the idea that this is a matter of Democrats versus Republicans. The reality is that the scandal is about whether or not we live under the rule of law. And that is not a conservative or a liberal debate. That is an American value. And for that reason, there are numerous conservatives, and I don't mean wishy-washy conservatives, I mean hardcore doctrinaire conservatives, from Grover Norquist and Bob Barr and David Keene of the American Conservative Union, and scores of senators who are quite conservative, who have expressed not just concern but anger over what the Bush administration has done here in ignoring congressional law. Bruce Fein, who's a colleague of Professor Turner's in the Reagan administration, wrote an op-ed in the Wall Street Journal saying that if the Bush administration does not immediately cease this lawbreaking, that George Bush ought to be impeached. This is a scandal that implicates core American political values as to what kind of country we are and what kind of country we want to be. The other point I want to make is nobody is against eavesdropping on al-Qaeda, and Professor Turner knows this, despite saying this is about whether we should hang up on Osama bin Laden. We have a law in place, the purpose of which is to enable the government to eavesdrop on terrorists. We all want eavesdropping on terrorists. That's why we have a law in place. That's why Democrats and Republicans came together to make that law stronger in the wake of 9/11. And that's why President Bush said that that law gives him all the power we need. The scandal is not about whether we should be eavesdropping. We're going to eavesdrop. We should be eavesdropping. The question is about whether the president will exercise the awesome power of being able to eavesdrop on the communication of American citizens in violation of the law, meaning without judicial oversight, without anyone knowing what he's doing, or in accordance with the law, meaning with judicial approval by the secret FISA court. Professor Turner said the only people who are being eavesdropped on are the bad, evil al-Qaeda people. He has actually no idea how these powers have been used because the law requires that the court, the secret FISA court, oversee how the eavesdropping is being done. That's the law that the Bush administration violated and instead eavesdropped in secret. So nobody has any idea who has been eavesdropped on, how the eavesdropping power has been used, precisely because the administration broke the law. They didn't break the law by eavesdropping. We all want eavesdropping, aggressive eavesdropping on al-Qaeda. They broke the law by eavesdropping without the judicial oversight that that law requires.
Omaha, Nebraska.
Yes, good morning. This leads right into the question that I have, because when you look at the FICA laws, it's based on the controlling of the information after you get it. Who's controlling this information? Where does it go? When you find the wiretap laws, they have restrictions on who's able to review this information. So as you say, once you take it out of the court's jurisdiction and the Bush administration gets it, who's controlling this information? Where is it being reviewed at? Who has the hand on it?
Mr. Greenwald.
I think the caller places his finger on exactly what the problem here is, and that is in 1978, we realized that the power to eavesdrop on American citizens is an extraordinary power, and it has been abused by Republican and Democratic administration for decades. And as a result, we said we trust our government, the federal government, to have this power only if someone is watching over them. And that someone is the FISA court that is expert in the law and that is trusted to keep the country's secrets. And that was the way that we could assure ourselves that this power would not be abused, by ensuring that the president abided by the law. Since the president broke the law and is eavesdropping in secret, nobody has any idea how the power has been used or what has been done with that information, including Professor Turner.
Professor?
Well, I do have some background on this. Glenn mentioned I worked in the Reagan administration. From 1981 to 1984, I was counsel to the President's Intelligence Oversight Board at the White House. I was the guy that when the NSA made a mistake and inadvertently intercepted a communication of a U.S. person without a FISA warrant, they had to make a report to me. So I followed the law fairly closely. Several things involved here. One, FISA is a relatively slow process. That is to say, before you can seek a FISA warrant, you have to be able to the Attorney General has to certify to the court that there is probable cause that the U.S. person involved in the conversation is a foreign, either a foreign power or agent of a foreign power. Now, foreign power is defined to include terrorist groups. But what do we do when we have a foreign person on the call who we can legally tap? Everybody knows that, or listen to, and who we know may be bin Laden himself. But if he's talking to an American, sending an email to an American that we don't know anything about, we can't certify to the FISA court that this person is an agent of al-Qaeda. Moussaoui was not even an agent of al-Qaeda. He was a lone wolf, which again is why we could not stop 911 because Congress had written the law. Now, every court has said the president has this power. Glenn keeps talking about we're breaking the law, but there's a hierarchy. The Constitution is higher, and if we allow Congress to usurp the president's powers, which is what's going on here, that will be a tremendous loss to us. We will lose separation of powers. Congress has certain checks. They're spelled out in the Constitution, but in foreign affairs, they are narrow checks. There's all sorts of Supreme Court jurisprudence on this. You know, this has been reported to Congress. It's a narrow program. And also, when NSA does intercept a conversation with a U.S. person that is in fact innocent, let's say bin Laden is buying a lamp, they have minimization procedures by which they have to destroy the record and report it to the White House and to the Congress. So this is not unchecked power. This is just like arguing that before a private can pull the trigger in a combat zone, he has to bring the target back to the United States for some court to decide, well, you know, could this person have mitigating circumstances? Was he really walking across the battlefield carrying his AK-47 on the way to the Rod and Gun Club for a turkey shoot rather than being an enemy soldier? There are mistakes that are made, and there will be mistakes that are made when you entrust great power to the executive. But if you don't give the president the power that's necessary to fight and win wars, the consequences to the American people will be far greater than the civil liberties violations that will certainly occur through this kind of a program.
To show you how the visibility of this hearing that's coming up in just a little bit of an hour is in the newspapers today. Here is the op-ed page of the Wall Street Journal, where the Attorney General, Alberto Gonzales, has an op-ed kind of laying out the argument, presumably the argument that he's going to be making today. And I'm going to take this away and show you a full-page ad in this morning's this morning's USA Today that is done by the American Civil Liberties Union, in which they talk about Mr. Gonzales and Mr. Bush saying that the president is spying and Congress must act. You are a blogger.
I am.
And I asked you that because I was reading your blog that you did yesterday, in which you talked about the fact that you're going to go to the committee and you're going to sit in the room and blog live.
I believe it's still being worked out, but I'm going to be in the committee with a press pass, and I think I'll be able to live blog the hearings.
Let me ask you then about this quote from yesterday's blog. Anyone with any hopes that Senator Specter is going to act with integrity or objectivity at the hearings should go ahead and accept that that's a total delusion so that you're not disappointed. Why do you say that?
Well, this is why I say that. And I had alluded to before the fact that it is very odd for the Bush administration to say that they had authority to eavesdrop outside of FISA and without warrants, given that had they had the authority, they could have said so in the past 4 years without disclosing operational details. We don't need FISA to eavesdrop because we have the authority under the Constitution that Professor Turner says we have. Not only didn't they do that, President Bush went around the country and misled the American people. It's not that he didn't tell us what he was doing. He made false statements about what the government was doing. This is what he said on April 20th, 2004 in Buffalo, New York. He said, now, by the way, any time you hear the United States government talking about wiretap, a wiretap requires a court order. Nothing has changed, by the way. When we're talking about chasing down terrorists, we're talking about getting a court order before we do so. He told the American people that when they eavesdrop, in order to catch terrorists, they go to the court and get a court order. We now know, thanks to the New York Times, that that was false. Senator Specter was asked about this quote by Tim Russert on Meet the Press, and Mr. Russert said, which is not just a good question, but an obvious question, Senator Specter, isn't this quite misleading for the president to have said this? Obviously it is. It's false. Senator Specter said, well, it's a good question. It might be misleading, but it also might not be misleading because maybe he only meant the eavesdropping that we do domestically, in which case what he said was accurate. If he meant all eavesdropping, then yes, it was wrong. The reason I said that that indicates that Senator Specter will do what he always does, which is make some noises of protest but then fall in line obediently behind the president, is because you can't defend President Bush's statement without changing what it is that he said. Senator Specter said maybe he meant, well, we get warrants only when we eavesdrop domestically. That isn't what he said. What he said, the president said, was anytime we eavesdrop. And so I think anyone who can't acknowledge that the president's statement is a misstatement, is a misleading and false statement, is someone who is going to defend the president no matter what. And that's what led to my concerns about the objectivity of Senator Specter.
Mr. Turner, what should the Attorney General do today, and what should members of the Senate Judiciary Committee who approve of the president's actions do today to make their case?
Well, just a 10-second aside, I've dealt with Arlen Specter going back to the early 80s. He's a man of high principle, a very honorable man. I don't always agree with him, especially on constitutional issues, but the idea that he's somehow a flack for the administration or something it's outrageous. Now, what the administration should do, I think, is make the point that this is a legal operation. That is to say, as I've said before, every court of appeals to consider it says the president has inherent power to do this. The review court created by FISA said that FISA can't take away that power. So this has been reported to Congress over a dozen times. This is not, you know, the critics are trying to portray this as some sinister operation. You know, oh, well, he didn't tell us about this. He deceived, perhaps. Well, we need to go back and get FDR. Did you realize that during World War II, we did not announce to the world that D-Day was going to land at Omaha Beach? We even set up George Patton to mislead the press into thinking they were going to go somewhere else. I mean, how outrageous in time of war to try to mislead our enemy and make our enemy let down their guard if they think they can communicate in comfort because we can't listen. Maybe they're going to say something about the next attack and we can save some American lives. So I just think this is silliness. Now, what I think they're going to do is primarily argue statutory authorization, and that is to say FISA permits eavesdropping or electronic intercepts when authorized by statute. The Supreme Court in the Hanby case held that although there's a federal law that prohibits detaining Americans without statutory authorization, the Supreme Court, or at least 5 members of the court, the plurality opinion by Justice O'Connor and Justice Thomas in his dissenting opinion, held that by authorizing force, the authorization of the use of military force statute that was passed a few days after 9/11 gave the president the power to engage in all of the normal incidents of war. Now, as important as sending aircraft carriers into battle is collecting intelligence on the enemy. We might have lost World War II, and certainly it would have gone on for years had we not broken the Japanese and German codes. So this is obviously an incident of war, and it is a statute, and so it passes a straight face test to say that statute authorized the president to do this. I suspect they're not going to make the constitutional argument as strong, although it's not true to say they've never questioned the constitutionality of FISA. On the 19th of January, the Justice Department issued a lengthy legal brief that said if FISA were interpreted to block this kind of program, it would be unconstitutional, and that is certainly true. And again, all the courts are on the president's side. The chairman of the Senate Intelligence Committee, if he felt aggrieved, he would complain about this. He says, I knew about it, and he also says, as I read his letter, that we urged the president not to seek a revision of this because we didn't think it could be done without tipping off Al-Qaeda as to the kind of thing we were going to do. So I think we've got a lot of people trying to make this a partisan issue. We've got a lot of people that generally like George Bush who honestly do not understand this area of the law. It's a very complex area of the law.
I need to get back to the phones. Northport, Florida. Go ahead.
Yes, I'm calling in reference to the terrorist spying in 1978. Were we not? We were done with the Cold War and we were at peacetime. Well, we were attacked on 9/11. If it was up to Mr. Greenwald, we'd be back into pre-9/11 situations. Well, I'm sorry. I'm glad the president's protecting us, and people like you, thank God you're not protecting us, because if it were up to you, we not be protected. We would be open to attack again. And not only that, I believe the president has those powers. If Congress is just jealous because they don't have the power to fight war. They only are the ones to vote for war. Thank God, the people that they're not fighting the war, because if they were, look where we would be. We'd be right back to before 9/11, and that's how we got in the position that we were in then. And Mr. Bush is connecting the dots, and thank God we have a president that has the courage to do so. And Mr. Greenwald, I think you need to go back to constitutional law, because I think you need to learn it all over again.
Mr. Greenwald.
I think, first of all, I think it would come to as news to a lot of people to learn that in 1978 the Cold War was over. The Cold War was very much alive in 1978. The Soviet Union was quite strong, and in fact, leading into the Reagan administration, we were constantly told that the Soviet Union was the great evil empire that threatened our country's existence, and there was a good argument to make that it in fact did. That is the crucial point. We are a country that has faced extremely serious threats on multiple occasions throughout our nation's history. We never decided that we were going to be a country that allowed the president to violate the law, or that we were going to relinquish our basic American political values in the name of fighting those threats. A strong country insists upon its basic constitutional protections, especially when it faces a threat. Professor Turner keeps analogizing where we are to World War II and to other wars. It's critically important to realize that the administration and all of its defenders continuously tell us that the conflict against global terrorism is one that is going to be measured not by years, but by decades, which means that the kind of powers that Professor Turner and others are urging that we give to President Bush, these broad powers to conduct war powers in the United States against American citizens, is something that's going to last not for a few years like World War II did, but for the next several decades. These are powers that we will be giving to the president for basically the rest of our lifetime. And Americans have to decide whether or not we really want to radically restructure our government, basically for the rest of our lives, in the name of the threat of al-Qaeda. I think that a strong country like America can continue to live under the Constitution and live under a system of government where when Congress passes a law saying it's a crime to do something, the president is not allowed to do it. If the laws need changing, if they're bad laws, if we need to make the laws so that the president has more powers, we get together as a democracy and we amend the law like we did in the aftermath of September 11th. But we do not want to be a country, particularly for the next several decades while this conflict lasts, where we throw away all of the constitutional principles that have made our country great.
Amherst, Massachusetts.
Oh, good morning. How are you today?
Good.
Boy, you got two filibusters there today. I think the key element here that's not being discussed, and it's a key part of the process, is the warrant. The warrant is a bill of particulars. It's proof, it's evidence, it's a hard copy that the event actually ever took place. That is the surveillance, the investigation. You show up in court without a warrant, neither party has a ground to stand on. The warrant is the proof, hard copy, time, date, event, why the investigation, surveillance, or the search and seizure took place. The government's probably is handicapping itself by not having a warrant, because the warrant says the event took place, time, place, and the particulars. Who was it? Was it that actual phone number? Maybe it was the wrong phone number. So can somebody speak about the warrant?
Mr. Turner.
Sure, I'll be happy to. The warrant is a fundamental part of our criminal justice process. We're fighting a war. Every president since George Washington was General Washington, even before we had a constitution, has engaged in warrantless surveillance of enemy communications. George Washington authorized the surreptitious interception and reading of mail coming from Great Britain to Americans. Woodrow Wilson engaged in electronic intercepts. FDR did so. This is not a power. Glenn keeps confusing this and thinking that we are giving power to the president. All the president is doing is exercising powers with much more modern technology that every president during wartime has used, that every court to consider the issue has said the president has independent constitutional grounds to use. Now, why don't you want to get a warrant? If, again, all of these conversations involve foreign nationals outside this country who we believe belong to al-Qaeda, who are communicating with people, often people we know nothing about, inside this country. to get a warrant for criminal purposes, you would probably assign the FBI to try to find out what they could about the recipient. You might get the name somehow, and then you would say, follow him around, see what he does, see if you can get evidence he's working for Al-Qaeda. You cannot certify to the FISA court that this individual is an agent of Al-Qaeda, because he could just be somebody who sold something on eBay. There are communications made by terrorists that have nothing to do with terrorism. And so the question is, and there may be hundreds of these that you want to narrow it down. The Washington Post yesterday said that this process has led to intensive investigation of what they say about a dozen Americans a year. This is not a great big sweep. But do you want to say, let's say, let me give you a hypothetical. I'm bin Laden. I want to communicate a bomb plan. So I send out an email and I spam 500 Americans with it, mostly picking elderly people that I learned don't use their email very often. And my subject line says, cheap Mexican Viagra. And then I have 2 pages of just gibberish about Viagra. And then at the bottom it says, on Tuesday, pick up the bombs from Muhammad and blow up the Lincoln Tunnel. Okay, how many of those Americans are not going to delete that the first time they see Viagra on their screen? But are you going to say, we can't look at that message until the FBI tracks down all 500 of those recipients and make sure they're all enemy agents so we don't violate the privacy rights of the other one? This is silliness. We're in a war. Presidents have always done this. The president ought to be allowed to do this. I don't hear anybody saying we shouldn't be listening to communications between Al-Qaeda and Americans. To get a FISA warrant for each one of those recipients, you would first of all have to go to NSA lawyers who would have to look at the facts and decide, is there probable cause? All right, then they would go to the Justice Department, to the Office of Intelligence Policy and Review, and they would staff it and see what they could do, and then it would be sent over and it would go to the Attorney General's office, and another cabinet member or another presidential appointee has to sign off. Then you'd get in line and go to the court, which by this time would probably have 20,000 of these warrants waiting for it to get to, because it would be easy for Al-Qaeda to put 10,000 people on a spam list knowing nobody would understand it, especially if you encoded the little bit of information at the end. And we would be spending days, weeks, or months in a setting where minutes might make a difference between saving tens of thousands of lives.
Mr. Turner, hold that last one. Mr. Greenwald.
Thank you. The line of cases that Professor Turner keeps referencing that said that the president has the right to engage in eavesdropping were all cases that were decided prior to the time that FISA was enacted. And most importantly, no court has ever said that the president can eavesdrop on American citizens in a way that Congress has made it a crime to do so. And that's obvious that that's the case, because we don't have a country where Congress passes a law making it a crime to engage in behavior and the president can engage in it. Yes, there are presidents who have engaged in warrantless eavesdropping throughout history. All of that was before it was illegal to do so. And the idea that, well, once somebody gets caught breaking a law, they can give excuses as to why the law was a bad law is not a principle that we have in our system of government. The president said, once Congress amended FISA in 2001, after the 2001 attacks, the president came to Congress and said, I need additional powers. Republicans and Democrats got together, amended the law to give President Bush everything that he wanted. And this is what President Bush said in October of 2001 about FISA, about the law that he ended up violating. The new law recognizes the realities and dangers posed by the modern terrorist. Surveillance of communication is an essential method, but for a long time we have been working under laws written in the era of rotary telephones. Under the new law, officials may conduct court-ordered surveillance of all modern forms of communication used by terrorists. The law that we have in place is the law President Bush wanted, that said that he needed to get to eavesdrop on terrorists. He should have abided by that law. If he wanted the law changed, he could have gone to Congress, which is controlled by his own party, and got the changes to the law that he wanted. That's what a government and a nation that lives under the rule of law does. Not secretly break the law, and then once it's broken, start finding excuses as to why he was allowed to break it.
Los Gatos, California. Thank you for waiting.
Yes, Mr. Greenwald, I think you ought to try to cover up your anti-Bush bias a little better. You know, the whole nation, quite a few people are watching this. Mr. Turner, you mentioned that you thought he was, Mr. Greenwald was confused. He isn't confused. He's just before I get to that, Mr. Greenwald, did you know that Bobby Kennedy was caught wiretapping Martin Luther King, a Democrat, I do believe, And back to my point, Mr. Turner, you said you believe Mr. Greenwald was confused. He's not confused. He's a mind-numb robot of the left.
What are you going to look for today?
I'm going to look for whether or not the senators on both sides of the aisle are going to defend the principle that in our system of government, when Congress enacts a law, the president is required to abide by that law, and whether or not it's acceptable or not under our system of government for the president to mislead the Congress and mislead the American public about what it is that he's doing in terms of abiding by the law. What I'm going to look for is to see whether or not the members of Congress will finally insist that in our system of government, the Congress, which is the representatives of the people, have a significant role to play in ensuring that our laws are adhered to by all citizens, including the president.
And where can people read your blog and respond?
It'll be, the address is glenngreenwald.blogspot.com, and I will have real-time commentary about the hearings, about the questioning of Attorney General Gonzalez as the hearing progresses.
Mr. Turner, should Senator Specter subpoena other people for these hearings, people who have some inside knowledge about this?
I don't think he needs to subpoena anybody. I think he should bring in other people, but he ought to try to find people that know something about national security law. It's embarrassing. An awful lot of very good constitutional lawyers have been making pronouncements on this issue that simply don't understand the background. Foreign affairs is different from domestic affairs. Again, the issue here is not whether we should obey the law, but what law is supreme. The Constitution gives the president a great deal of unconstrained power, and the Supreme Court has noted that time and again. Often it's checked in broad terms. The president can't spend money unless Congress appropriates it and so forth. But in terms of Congress checking decisions on the battlefield and the conduct of war, never happened, and if it did happen, we'd probably lose the war. Glenn says that all the court decisions were before FISA. The FISA created the Foreign Intelligence Surveillance Court of Review that said if the president has this power under the Constitution, as all the earlier courts said, and the Constitution couldn't be changed by FISA, then FISA cannot take this power away from the president. And that's the issue here. It's a very important issue, but there's been an awful lot of confusion and some downright misdirection when people are saying the president claims the power to spy on any American and claims he's above the law. He's doing what every president has done during wartime. He's reported it to Congress more than a dozen times. And if there's a dispute between these the statute and the Constitution wins every time.
Robert Turner is director of the Center for National Security Law at the University of Virginia Law School, rather associate director there. And Glenn Greenwald is a constitutional law attorney. Thank you both for joining us today.
Thank you.
Thank you, Connie.
We're going to continue with open phones for the next few minutes, and I'm going to show you, you'll see the phone numbers at the bottom of your screen, but let me just show you how some of the newspapers